Should a convicted triple murderer get another chance? 3 people dead after a family lunch. The so-called mushroom murders shocked Australia. But the story isn't over. Erin Patterson, the woman convicted of killing her in-laws, has just filed a major appeal, saying that her trial was unfair, while prosecutors are also appealing, saying that her sentence was too lenient. So, how can both sides appeal the same case? And what does that tell us about how justice actually works? Let's decode it. Erin Patterson, 51, was found guilty in July 2025 of 3 counts of murder and 1 count of attempted murder after serving a beef Wellington allegedly laced with death cap mushrooms to her family in Leongatha, Victoria. In September 2025, she was sentenced to a term of life imprisonment with a 33-year non-parole period. But within weeks of sentencing, both the defense and the prosecution have filed appeals. And that's where the story starts to get legally fascinating. So let's start with Erin Patterson herself. Her lawyers have filed 7 grounds of appeal. They're arguing that the trial was riddled with unfairness. They're claiming that she was subjected to unfair and oppressive questioning and cross-examination, amounting to a miscarriage of justice. They're arguing that there was a fundamental irregularity with the jury because the jurors were housed in a hotel with police officers and news reporters, journalists, which they say could have tainted deliberations, even though the police officers and the journalists were told that they couldn't talk to any of the jurors. They say that key evidence should have never been admitted. The mobile phone tower data, Facebook connections from true crime groups, and mushroom-related photos. They're also saying that the prosecution changed its case theory between opening and closing, which they're implying a motive that hadn't been part of the trial until then. In short, Patterson's team argues that the verdict was unsafe and that the process was unfair. Now, the prosecution, or the Victorian DPP, Department of Public Prosecutions, has also launched their own appeal, and they are calling Erin Patterson's sentence manifestly inadequate. They're arguing that the trial judge has made a factual error by assuming Patterson would spend decades in solitary confinement. And they've used that assumption to set a shorter non-parole period. So that 33 years that she's been handed, they're saying that that is inadequate. So the DPP are lodging their appeal, and they're arguing that the claim wasn't supported by prison evidence and that this crime sits in the worst category of murder, meaning Patterson should either have a non-parole period that is a lot longer or that she should have no non-parole period and it should just be a flat life imprisonment. So I know you're all asking on the edge of your seat, what is an appeal? Now, an appeal is not a retrial. An appeal is a review by a higher court of whether the trial judge applied the law correctly or whether the process was fair. So in Victoria, where this took place, a conviction appeal challenges the guilty verdict, which is what Erin Patterson is going for, and a sentence appeal, which is what the prosecutions are going for, challenges the punishment. Now, challenging the punishment would be saying either the sentence was too harsh or too lenient. So in any appeal matter, leave or permission from the court needs to be granted in order to even kick off this whole process. And in Patterson's case, leave was granted. So why does it matter? Dual appeals like this are so rare. It means that the Court of Appeal is going to look at both the fairness of the conviction and whether the punishment actually fits the crime at the same time. And that is such a rare situation. From a criminology and legal studies perspective, it raises some pretty big questions. How does the justice system balance deterrence and retribution against fair process? Does public outrage pressure courts to be harsher than they are? Can due process survive intense media pressure? And what happens to public confidence when someone convicted of a shocking crime like murder is given another shot in court? For law students and true crime enthusiasts, this is where the law and morality collide. The hearing of this is likely going to take place in early 2026, and it could reshape one of Australia's most infamous murder cases. And since it's not likely to take place until early 2026, I think this would be a really good time for us to talk about things like murder. What distinguishes murder from manslaughter? And what distinguishes involuntary manslaughter from voluntary manslaughter, infanticide, filicide, parenticide, all of those things. I think it's also a really interesting time for us to talk about juries in Australia, how they're formed, what the rules are, how they're selected, and all of those things. I think that could be really interesting for us to go through. So, to recap today's episode, Erin Patterson says her trial was unfair and that the verdict was unsafe. Prosecutors say her sentence was way too light and based on a factual mistake. In episode 2, we're going to break down the specific legal grounds one by one. What counts as an unreasonable verdict? How manifestly inadequate is proven? And what kinds of errors actually overturn a case in Australia? Make sure you follow Decoding Deviants, aka me, Krista, for that deep dive. And drop your thoughts in the comment section below. Or is this exactly why appeals exist? To make sure that justice is done properly.